of course, this is not going to explain everything about how a deposition is conducted, but this is just to be so that you understand what it is. Not for the attorneys, they know what a deposition is, but especially for support staff to understand what it is, what they're getting ready for. What usually happens in a lot of firms is that you're an associate, you come to a law firm, and you're hanging out for a couple of months, and you're sent on court appearances, and you're feeling like a lawyer, because you're going to court. And then it becomes apparent to you that you're just running errands and making appearances just to show face, to show there's a living body that's handling the case. Finally, you get assigned to do a deposition. And I'm going to tell you right now that if you haven't done one, that's when you really start feeling like an attorney for the first time, unless, of course, you've tried a case or have been into the arbitration process, because you're put into control. And here's where the scary part comes in. You are in control of the whole thing. If you are the one who's conducting the deposition, then you're responsible for everything. Everybody's looking to you to start the process. Online, it's a little bit different, but if you come in live, you have your conference room, and hopefully you're not there late, but if you do come in late, you'll see the court reporter sitting there with their machines, and they're taking everything down, and you have your opposing counsel there, and there's witnesses there, and sometimes the party for the other side who's not being deposed, or your client, is going to be there as well. And the first rule of depositions is that anybody who's named in the caption is entitled to be there. The attorney does not decide. The attorney cannot say, or should not say, you're not allowed to come because you distract me. That's just the way. They have an absolute right to be there. Now, have I said that, and has Tasso said that to clients, that we don't want them there because they're distracting? Absolutely yes. Because they start writing notes to you, and they start whispering in your ear, and it just knocks you off of your whole game. And if they can't refrain from doing that, then you have to tell them, sorry, you're going to have to wait for the transcript. If you don't like it, then just go to another attorney. But they do have an absolute right to be there. And even if the room has been crowded, they're parties, they're allowed to be in there. That's just how it is. And imagine if you were in the lawsuit and somebody was telling you couldn't be there to hear the testimony of one of the parties. So anyway, that's really the first rule. So you walk in, and everybody's looking at you, and it's your first deposition, and no one really trained you properly, and you've never been to one before. So it's a pretty scary situation, But from today forward, at least you will know that you will have your card ready to give to the court reporter and to your opposing counsel. Because they may not know you, they may not have your contact information, and that's just protocol, that you hand out your card to everybody, to the attorneys only, and to the court reporter who is there. And hopefully you will have a copy of the caption along with the parties and who is represented by whom. And they'll say, do you have anything with the caption on it? That's the court reporter. They shouldn't have to ask. You should hand that right to them along with your card. I'm Joe. I represent the defendant on this case. I'm conducting the deposition. That's how you introduce yourself to the court reporter. You sit down after you say hello, and everybody's still looking at you. The court reporter is writing things down. She has her sheets here, and she's writing everybody's names down. So that sheet that she's writing on, are you ready for this? Here's the first word of the trade. It's called the dog sheet. No one knows why it's called a dog sheet. Toss, no jokes, but it's called the dog sheet. And you would think that that's not really important, but it may become important at some time if you're trying to track down a transcript, or to track down a party, to track down an attorney, because the court reporter's dog sheet is going to have all that information. So that if you're missing something, you could have the admin call up the court reporting service to say, hey, we just did the deposition in September. Do you have the dog sheet available? We're trying to find out the name of who's also present at the deposition. So it's very valuable, and they'll know exactly what you're talking about. They'll specifically go to the court reporter's dog sheet. As you're sitting down, you're taking out your legal pad, and you're taking down the name of the court reporter. And it's they understand, they know, they say they're expecting for you to take down their full name and the company that they're working for. Okay, again, for purposes of tracking down the transcript. So I know we haven't gotten into the substantive stuff. We will get there, but these are the initial things of what you do before anything even gets started. And the court reporter is talking to the witness, which is okay. They're taking down information, asking what their names are, what their addresses are. If it's a corporate client, they may not want to give their residence. That's okay. They can give their business address, and then it's usually stipulated by the parties, attorneys, that in the event that this person has to be subpoenaed, that the lawyer will agree to accept service of the subpoena and produce this person at trial. You got that? So this way they don't have to give their address up in Scarsdale or, wherever it is that they don't want people knowing where, they're, even though it's probably readily available, they don't want it on record, because the transcript is going to be a record. It's going to be part of court filings. There may be information that's not properly redacted, and they don't want the public to have access to it. So that's okay. All right. So they'll give so now this witness has not even been sworn in yet. You're still chatting, with your opposing counsel, cracking jokes or whatever, and this stuff is all going on. You have to take control at this point and say, let me know when you've sworn the witness. First two questions are on the record. Just give me the green light and we can begin. Okay? That's what you say, because the first two questions will be, what's your name, what's your address? What is your name, where do you live? No matter how you phrase those two questions, it's going in the way the court reporter has it already preset. It's okay. All right? Unless those really aren't your first two questions, which I don't know why they wouldn't be, but it's always good to have on the record who you're speaking to right at the front. So those are going to be your first two questions. So you say, let me know when you have the first two on, and give me the green, make sure, swear in the witness, first two on, give me the green light when you're ready to proceed. All right? So that's how that's the beginning of the deposition. And now, you're totally unprepared. You have no questions prepared. It's an auto accident case. Our client has no insurance, and we're the counsel for them because their insurance company did not provide any defense, which is what happens if you have a lapse in insurance. They will not defend or indemnify the case. Your insurance company, that for your car, those premiums that you pay every year are for purposes of one of the purposes of getting into an accident. You run somebody over at the intersection, you call up your insurance company, they assign an attorney to you after you're sued, and they try to settle the case for you. If you do not have insurance because you did not pay your insurance, like we have a few cases like that, then you have to go out and get your own attorney. So here we are at our deposition defending the person who did not have insurance, and we're going to find out about the injured party, and that's who we are deposing today. And you see them sitting there, they have their neck brace on, their cane is leaning up against the wall. The plaintiff is breathing heavily to indicate to everybody that they are in pain or whatever, or discomfort or whatever it is. That's okay. That's not going on the record, but that's what happens a lot of times. Don't let that upset you. It's all good. But you don't have your questions thought out ahead of time, and you really have no plan because you weren't properly trained. It becomes a problem because you start questioning, like, I don't know, let's just say, all right, you gave us your name and your address. So where did the accident take place? Okay, which is, I get it. You're getting right to the core of the problem, and you're asking about the accident. Well, I'm going to tell you right now, just going directly in that way, you're not going to get much information, and you're going to leave the deposition without a lot of information that you need. So what we do is we go back in time before we have asked the court reporter if they have sworn the witness in, and to let you know when this is all done and to give you the green light to begin your questioning. And we go to the night before, and we start thinking about what it is that we're doing at this deposition. You know, if you have a whole night to think about the deposition, you don't need the whole night, but you're in good shape because you could start thinking about a strategy. You're not going to go in there and have very few questions to ask. If you go in with no plan and you don't have experience, your deposition is going to be over in 15, 20 minutes, and you're going to feel like something is very wrong. And that's because something is very wrong and you didn't get the information most of the time that you need. I mean, there have been depositions of parties that have gone, 20 minutes and you got everything that you need from that particular person. But now you had time to think about it. And the best way, no matter what kind of case it is, and Tasso always talks about this too when we're talking about prepping for, for examining a witness at trial, is you think of a quadrant, okay? And each quadrant is going to contain information that you want to get in that quadrant, okay? And it should be planned out. So in the first quadrant of your schematic for your deposition, it's going to be background, pedigree information. Tell us about, give us your biography. So something that we can relate to with biographies when we're doing the pre-sentence reports for our defendants in criminal cases. We're getting their story. We want to find out who they are. And you think it's not important because we're just talking about a car accident, but we want to find out everything about this person now before a jury hears about it. Now, if this is a really bad person, this is great information, and you can, just based on their bad history, you have a pretty good start in the defense of the case, because now the jury's going to hate this guy, or the jury's not going to believe this guy, depending on the information that you got. But you could also have a hero. You could have, this could be a healthcare provider during the COVID emergency, and they've saved people, and they've received awards and everything. And you know what? The jury's going to hear all about this stuff because it's background information. Although it's not relevant directly to the lawsuit, you're allowed to build up who this person is to the jury, to explain who they are, to make them human. So you want to find out in that first quadrant. First thing is, who am I dealing with? And your questions, you have to ask your questions beginning with broad and then narrowing down to specific. So you ask a question, about them. It's going to, the answer to that one question should bracket into many other questions. And I'm going to give you an example of how that works. But in the bio information that we're getting from them, okay, we have their name, we have their address, we're going to get their social security number, which you can leave blank in the transcript, but which you can agree to, as long as you collect that information there and write it down and confirm it so that the numbers are not on the record, not even the last 4 digits, but confirm that, is this the number that you gave to me? And this way we have a correct social security number. And why is it so important to have that? It's very important on the defense side in an injury case, because you're going to use that number to run it in CIB, which is an insurance database that has information containing all prior claims of this person. And they run that information, and all the claims that this person has made with the insurance company pops up and is collected. And you might find out that this guy has 20 claims, that they're a career injured party, which is very valuable, especially if you're dealing with a specific injury that they are claiming that they were injured in other accidents before. Okay, so you're going to get details, a lot of details with that, and you'll be able to get more information about those other accidents later on in discovery. But just from getting that one bit of information is going to be the key to doors that open up to other information that's going to be very, very valuable to you. So just that one question is very important. Here's another question that you're allowed to ask. I know it sounds crazy, it sounds very personal, but have you ever been convicted of a crime? Oh my God, objection. How is that relevant to the case? This isn't a criminal case. I love that one, because the CPLR, don't get bored yet, under 4513, it specifically allows you to introduce that evidence at trial. And all of the questions that you're asking, all they have to be is reasonably designed to lead you to information that's admissible at trial. not for it to be admissible itself, but to lead you to information. That's why the social security number is important, because that's not going to be admissible at trial, but it's going to lead you, or could reasonably lead you, to other information. And in state court, as long as you're not in the commercial part, that is the touchstone. Whether it's going to lead you to other information, that will be the test for the propriety of the question. In federal court and in the commercial part of the state court, the test is proportionality and relevance to the prosecution or defense. All right. And proportionality being that, is this the intrusion that you're about to undertake? Is it worth it in this kind of case? You know, you're asking about information that is like so, you know, that's so offensive. You know, is it proportional that you get this information to the type of case? This is a personal injury case, you know, that's the test. And do you really need this information to defend your case? All right. So in federal court, commercial part is proportionality, relevance, and in state court is reasonably lead you to. So that's the crossroad. A little bit different. It's a little more broad. The questions are a little bit more forgiving. You can get the information in state court. In the federal court, it's a little more narrow, not by much. Okay, that's the only difference. Okay, so you have two questions that are going to lead. You find out that this guy has been convicted of a crime. That's going to be introduced and presented to the jury. Oh, there's such a hero. Well, you were convicted in 2005 of robbing the store. Isn't that correct? And they can't say no, because you're going to have a certified copy, or you're going to have in the transcript that they admitted that they were in fact arrested, and they even did time. You know, it may be limited as to, you know, how much information about the conviction is given, but the jury's going to know that, hey, we got a criminal here. And you know how valuable that is, because you're allowed to impeach and say things like, you know, this person, you know, this is during your closing argument. This person was convicted of a crime. They have held their personal private interests over the interests of everybody else. And now they're here in court asking everybody to be interested for them as well. They refuse to follow the law. Now they want you to follow the law. They want the defendant to follow the law. It goes to their credibility. It's coming in. The people are going to hear about it. Once that question is asked, then they're on notice that this is going to be used at trial and the jury is going to hear it. So it reduces the value of the case and increases the potential to settle the case. So now you have two really important questions that are going to get you more information and devalue, hopefully, their case. The answer may be no. You know what? That's okay. Do you live with that? Are you stuck with it? No, because you'd have an investigator go and find out if they were, and you find out, oh my God, 20 years ago, they were convicted of a crime in Pennsylvania. All right. Now, here's a problem, because under the federal rules of evidence, if it's more than 10 years, so it's not coming in. But in New York, under 4513, any conviction comes in. So in the state court, it's very, very valuable to you. All right, because it can be introduced at any time. Now, the fact that it's 20 years old can be introduced, but still, it's something. You may have a case that's nothing. This is the deposition is the opportunity for you to turn your crappy case into something that is defensible. Even if you come away with one little thing, it was worth doing the deposition. The worse your case is, usually the longer your deposition is going to be, because you want to find out as much as you possibly can going down these roads. Look, we're just in the first quadrant of our questioning, and already we've gotten so much valuable information here. The next thing is you want to find out if they have ever filed for bankruptcy protection. Bankruptcy, objection, how is that relevant? This is not a bankruptcy, there's nothing to do with bankruptcy. And I'm going to tell you how to deal with those objections in a minute, but let's just explain why it's relevant. If you have a personal injury case today, you get run over by a car and you have a case and you go and you sue, and next week you file for bankruptcy. That lawsuit is an asset that belongs to you. That lawsuit is an asset that belongs to you. So when you file for bankruptcy, you list all your assets, you must list that lawsuit. If you didn't list that case, then you can make a motion to dismiss, because you do not have standing to bring the lawsuit. You do not own that lawsuit. You're an improper party, and the case will be dismissed. How awesome is that? a lot of times, especially with the personal injury cases, they don't give up that information, or they forget it, or they don't know what they're supposed to give it. And they lose on this one minor it's not a minor technicality, but it seems like a small thing, but they lose their whole case just because they did not list that. And you were smart enough to ask that question. All right. So you got the social, you have their criminal background, and you have the fact that they filed for a bankruptcy. 3 huge opportunities. People usually ask the social security number question, but the other 2, they forget all the time. Not our attorneys, of course, but they forget it all the time. Such important questions. And if you're the plaintiff, you want to make sure that you get this information from your own client before you even go to the deposition, because you can go and you can amend your petition and include that, amend your schedule so that you include the asset on there. At least you'll still be entitled to that, and you will not be subject to or exposed to a 12b6 or to a motion to dismiss the case under 3211A of the CPLR. So these are really, really important questions that you got to get. And you have to know how to deal with the obstructing attorney on the other side who's refusing to allow their client to answer the question. Can you imagine this? This is your deposition that you have paid for the court reporter and possibly for your interpreter to be there, and now they're directing their client to not answer the question. Does an attorney even have that power? The answer is sometimes you do have that power. Most of the time, 99% of the time, you have no authority to do that. But what are you going to do? You're dealing with a moron, and all they want to do is argue. They don't want you to even get out of the first quadrant. They just would rather just pack your bags and get no questions answered and go home so they can work on their next case. My advice to you is to not argue with these people. And it's very simple. On the record, you say, are you directing your client to not answer my question? That you say to the attorney. And they say, I'm directing him to not answer the question. You look at the court reporter and you say, mark this question for a ruling. And move on to your next question. When you get back to the office and you get that transcript back, you make your motion to compel and for sanctions, and you will win on both counts. Unless the question is clearly violative of a constitutional protection, a privilege, or is palpably improper. And that palpably improper is such a high standard. It's got to be ridiculously unrelated to the case, offensively unrelated to the case, for it to be upheld, for you to direct your client to not answer the question. You have to be very careful about that. First of all, falling into the trap of arguing with your opposing counsel for an hour. I mean, look, your client is paying for that transcript and they're paying per page. So if you have, 20 pages of argument, in lawyers' parlance, they call it colloquy. It's cool, right? Colloquy. And that's when the lawyers are bantering back and forth over ridiculousness, such as the authority to direct your client to not answer a question. There is very, very limited authority to do that. You can remind counsel. You could even tell them that that's fine. I've marked it for a ruling and I'm going to make my motion to compel. And you can be assured that I'm going to be moving for sanctions, and you can be assured that you're going to lose. You have no authority to do this. I'm proceeding with the deposition. Please do not interrupt me going forward. You may, at some point during a break, speak to your brother or your sister and say, listen, are you really going to make me file this motion and get sanctions? Are you really going to embarrass me like that? I need the answer to this question. Just let me ask it and let's get past it, okay? 50% of the times you'll get it and it'll be over with and you won't have to make your motion and you'll get the information. So that's how you deal with attorneys who are obstructive in that way, or, they are megalomaniacs and think that they have that power. Okay, so just back to the first quadrant, we're going to move on to the next. You're getting their biographical information. You want to know if they've ever been known by any other names. Do they have an alias? Because you're going to put that into your searches as you're looking for them and looking for information on them. You're allowed to get your date of birth. And if your opposing counsel says, can we just not put it on the record and just have them state it and we'll have it X'd out, I agree to that. I don't want to get anybody in trouble. I don't want anybody, picking up their information and using it for fraudulent purposes. You're going to ask them, of course, where they lived before. That may be important. You don't know. You're going to be asking them about their family. You're going to be asking them whether they are a citizen or what their immigration status is. That's going to depend very much on the type of case. It's going to be fact specific as to what kind of case you're working on. Usually in a personal injury case, that's going to be irrelevant and you're not going to be allowed to ask it. But you know what? You can ask, right? If they direct their client to not to answer and say that that's palpably improper, mark it for a ruling and move on. You don't really need that information at that point, and you've reserved your right to go after it at a later date, and you made them nervous. And on the other hand, you may have counsel across the table who's fallen asleep. All right, that happens more often than you think. Hopefully that will not be one of you. You'll be paying attention to every single question, and you'll know the propriety or impropriety of it, and you'll be dealing with that accordingly. And another cool question to know is whether they received any kind of awards or commendations or anything from anything, from the federal government, the state government, the local community board, whatever. You want to know about these things because you can be assured at the trial that all this information is coming in, and they want to show the jury what a great person that they have here. So you want to know all this ahead of time before it goes to the jury. You want to know about whether they have served in the military or not. You're allowed to ask that question. You're entitled to an answer on it. And you can ask them if they received an honorable discharge or not. Again, that's going to go to credibility, kind of like the 4513 criminal conviction. It's important. It's going to go to credibility, so therefore it's going to be admissible. Again, the test is, whether or not it's going to lead you to admissible evidence. So in that instance, that question it meets that test. It could possibly lead you to information that you can use at trial to attack their credibility. So it is coming in. So here we are. I'm about to leave the first quadrant because the time is just going by very quickly. Are there any questions about what you can ask as far as pedigree, their background information? Anybody have anything? Any comments that they'd like to make at this point?
I just seen different viewpoints on whether or not you can ask about arrests because anyone could be arrested and found not guilty. And I know some people say that that's improper and some say you can ask it.
The answer to that is you may not ask. And I know that across the United States in various state courts, they have allowed that question. In New York, the question is not allowed for the reason that you stated, because it's irrelevant. If there's no conviction, they're presumed to have been innocent. In criminal cases, we actually have a Molyneux hearing before the trial begins to determine the answer as to whether or not those kinds of things can come in prior, uncharged crimes, whether they can come in. And there's a hearing on that to show, and and the people have to show why it would come in. And arrest is not coming in at trial. And asking whether they have been arrested does not pass the test as we have stated here. It's not going to lead you to admissible evidence at this point. You'd have to somehow develop it through your deposition. You need a good faith basis to ask if somebody has been, arrested. If you know that they have been, and the reason for the arrest is somehow related to the kind of case, and I'm not talking about credibility. I'm talking about showing a pattern, scheme, prior notice, something like that. It has to be something that other than for credibility purposes, because that's why we're bringing under 4513, the conviction is coming in to attack their credibility. They are willing to lie. They are willing to do things because they put their own interests above the interests of society. And they were convicted of that behavior. And arrest is you were just charged. So the answer to that is you can ask it. If they object, I wouldn't push it because it's going to lose. And I do not allow that question. That is one question where I will say, I'm directing my client to not answer that question. That question is patently improper and is highly offensive, and you should know better. I said, you want to ask about a prior conviction, we're ready for that question and we will answer that. But a prior arrest is not a proper question. Objection. And I'll even say, you know, mark this question for a ruling myself. You know what I mean? Just to be dramatic and to get that point across. You know, it's because the more you do that, the more control that you have. And when you walk in and you have control of the whole proceeding, everybody behaves a little bit better. If you don't have any gates up on the reservation, everybody's going to be wandering off and doing their own things and, you know, finishing your questions for you, rephrasing it to help you. They're not allowed to do that. While you're asking the questions, they got to sit there and they got to shut up. They're there by invitation. They don't have to be there. If they don't like it and they don't like how the proceedings are under the Federal Rules of Civil Procedure Rule 30 or the CPLR Article 31, then they can leave. But their client stays and they're going to answer the questions. Otherwise, they're going to have to face the judge. How's that for an answer, Israel?
Thank you, Joe.
You're welcome, buddy. Greg, you were going to say something?
How are you addressing citizenship status and deals for lost wages, future lost earnings, et cetera?
I ask the question, Greg. If I'm defending, I ask it. I'm not pushing it though, and you could possibly run into trouble. I do ask it. Eventually, we find out the answer to that as we proceed through discovery. But I don't push that on the deposition.
Thanks.
How about you? What's your opinion on that?
I always ask.
I always ask, but I don't push it.
I mark it for a ruling and usually never get back to it.
Yeah, I think that's the best practice, everybody. You know, if you're not sure, ask it. If it's objected to, are you directing your client to not answer the question? Yes, I am. Mark it for a ruling and continue on. You know, you might get lucky. You know, as I said, you're not going to know until you ask, you know, and there's no penalty. As long as you have a good faith basis for asking the question, you're not going to get sanctioned as long as you don't push it improperly. We're going to move on now to from the first quadrant now to the second quadrant. And in the second quadrant for a personal injury action, we are going to go to liability, meaning the accident itself. That's where we're going to proceed to. And we start from the very beginning, because remember, and you know, you have to look at the deposition. The court report is taking everything down, and you know, you're asking questions and they're giving an answer and everything's getting typed out, you know. So you have to think of this case as a blank transcript, a blank construct. So think of an empty room or an empty transcript, whichever is easier for you. And now you're going to put everything into the room. All right. So you're at the scene of blankness, and now you're going to create an intersection of 35th Street and Broadway and Astoria. And you're going to talk about the street. First of all, where it happened. Okay, it happened at 35th and Broadway. And can you describe Broadway? And they're going to describe it as a roadway that go with opposing traffic, you know, one lane each way, and it has a parking lane on either side. And is the intersection, is it controlled by a traffic control device of some sort, whether that's a light, you know, 3-phase light, 4-phase light, stop sign, or no? You know, so you're putting everything there through the witness by asking these questions as they're describing the roadway, so that by the time before you even got to how the accident happened, you have in the transcript created the intersection of 35th and Broadway with the caravan. And then you're gonna talk about what kind of day it was. Were the skies blue? Was it raining? Was it snowing? Was it, you know, you're getting all this background information, you know, until you get to the type of car. Let's say it was a 2-car accident, and you're asking them about their vehicle. And you're asking about the ownership of the vehicle, and, you know, the model and make of the vehicle, and what the physical condition of the vehicle was before the accident. You're getting all this information, asking questions, and just putting all these pieces together so that at some point you have their vehicle and your client's vehicle coming into contact with one another. All right, and that's how all the questions are geared. And then you find out how, you want to know, what are they going to tell the jurors? All right, what you're locking them down to their story. What is their narrative? And everybody knows who tries cases, and I said this before, and I know it's horrible and cynical. The jury's not voting for the one who's telling the truth. They're voting for the one whose narrative just makes more sense, because the truth is what each of the individuals perceived the truth to be at the time the accident happened. Like when party one saw the light, to them, it was red. But to somebody, to party two, when they saw the light at the same time, to them, it was really yellow. They're both the truth if they believe it, but what really happened, you're not going to know unless you have video surveillance of it. So it's not about, finding the truth. You're developing the better narrative, the one that the jury says, you know what, they're both great people. They were both healthcare providers during COVID, and they're both ex-military, and they both received medals. But party one's story just makes a little more sense, and that's all it takes in a jury trial. Preponderance of the evidence, just by that 51% to 49%. That's all it takes. So you're developing. You're locking them into their narrative. And if they have a crappy narrative at the time that you have asked your questions, you leave it. Do not change a word and move on to the next quadrant, which I'll explain to you in a minute. If their story is weak and that's their story, don't try to develop it any further. Because when they go to trial and they're embellishing on the story with all this other information, you're going to have their deposition transcript handy and saying is that all the information that you had about the accident? And this is everything that you wanted to tell us, correct? Yes, it is. All right. And you could tell them you remember that I, on October 1st of 2020, we had your deposition, right? And you had your attorney with you. And the attorney for our client was asking you questions on this date. Yes. And you were asked questions about how the accident happened. And it was asked, is this everything you have to say about how the accident happened? You answered yes. Well, I don't remember that. Well, you know what? I just happen to have a copy of your deposition transcript right here. And I'm just going to ask the court officer to hand this to you. And they take a look at it and say, turn to the last page. Is that your signature there? You signed that? Yes, that's my signature there. And I just refer you to page 20 and line 14. And I just want to ask you, were you asked the following questions and did you give the following answers? And then I read it off. Is this the entire story? This is exactly how the accident happened? Yes, it is. And you testified truthfully at the time, right? Because you took an oath at the time and you were telling the truth at that time. Isn't that correct? That this was the whole entire story. Isn't that correct? Because that's what I asked you. And they're going to say, yes, I am. And I say, and wouldn't you say it's fair? Is it fair to say that somebody's memory is better when it's closer in time to when an event took place rather than 2 years later as we are here now? Isn't that fair to say? And they say, no. It's like, okay. And then you're done, and then you put that into your summation bag. And remember, I asked them if their memory was better 2 years later than it was 6 months from the day of the accident. They said their memory was better 2 years later. Remember they told you that? It's a beautiful thing, and that's what the deposition does. That's what the purpose of the deposition is. So now we move from liability into the third quadrant, which is damages. And the damages portion goes into all of the medical treatment that took place from the time of the accident, when they got into the ambulance, up until the day that they're being questioned. That's going to be, you're talking about all the medical treatment that they had in that time, up until the time that they are testifying. So you have the names and addresses of all the doctors, what they did, what days they went, how many times they went, what medications they're taking, how much work you missed, what you did, for a living. All this great information is going to go into the medical treatment aspect of it, which actually the third quadrant should be called, medical treatment, because the fourth quadrant is what's going to be damages. And in the damages portion, you're going to be asking them the aftermath of this accident. What are all these things that you were able to do before the accident that you can't do now. And you're going to get everything that they did before the accident, because at trial, they're going to say, well, I went for, before I was able to run 5 miles and, I was deadlifting 300 or 400 pounds and I can't do those things. Yeah, and where did you go to do this lifting? It's like, oh, it's the Planet Fitness, and that's, you think that's not important, but Planet Fitness information is readily available to the to defense counsel to get on the check-in, check-outs, and their membership, and actually what dates and what times they went there. So all this can be verified, so it's all very valuable. You're going to be exploring all that in great detail, like about when they went to the gym, who they went with, what days they went, and then when the last time they, since the accident, although I can't go to the gym anymore. Well, did you try to go to the gym? And it gets pretty funny sometimes, but you have to maintain your cool, get all this information that you can, and you get it. And those are the really the 4 quadrants of a personal injury defense case. You can apply the quadrant methods to any kind of case. Of course, they'll have different names, but you should have a plan. You should, always, no matter, you're assigned to a deposition the night before, automatically your target comes up, your crosshairs come up, and you start filling it in. Okay, how am I going to attack this? And be organized. And make sure that you do not leave quadrant 1 until you've finished with everything that you need until you go to quadrant 2. Going in and out of the quadrants, that should not be done until after you've finished your deposition and you're collecting your thoughts and going over your questions, and you have any afterthoughts. And then you can go in and bounce around all you want. But if you follow the quadrant methodology, then you will at least come out with a solid deposition. Objections at trial, if you do not make an objection to an improper question, you're finished. On appeal, it's not preserved, and you're stuck with an answer. Example of a hearsay question, so what did you hear him say on the telephone? Oh, well, I heard him say that he was at fault, and he wishes that it never happened, and that is rank inadmissible hearsay for the most part. Just assuming that these 2 people are unavailable, and we don't even know who those 2 other people are. If there is no objection, or there is no objection hearsay, that question comes in and it stays in on appeal. At trial, if you don't object to it, you're gone. It's waived. At a deposition, the rules are a little bit different. At a deposition, all of that hearsay objection, you don't have to make, and you should not make that objection at a deposition. It is improper. You're allowed to ask for hearsay questions that call for hearsay. Any substantive objection is not going. You don't have to make that at trial. Only form questions. And what are the form questions? The one that we all know is the leading question, right? It's where you're going to get either a yes or no response, or they're going to give you a response that you are expecting the answer to. For example, here's the open-ended question. What color was the light at the intersection at 35th and Broadway for you? Answer, the light was red. The leading form is, so when you approach the intersection at 35th and Broadway, you had a red light, correct? Leading objection. You have to make that objection at the deposition, or else it is waived. But the form objections are the ones that you have to object to at the deposition, or it's waived. For example, if a question is confusing, so when you came to the intersection, what would you say happened then? It's kind of like you really don't know what they're going for. You object to the form. That's it. And you're okay. You just say objection form or objection. That's all you have to do. And then if the answer comes out to that question and it hurts you, and they try to introduce the testimony of the deposition at trial, and your objection is there, the judge is not going to allow it in. You have to point it out. And they say, look, I want to question them on this, on the deposition, where they said that the light was red. And you're going to say, Your Honor, if you look at line 14, our attorney objected to that question. It should not be allowed here. The counsel's trying to do an end run around to the rules of evidence by having this thing read into the record. and the objection will be sustained. If nothing is said, your objection is there in the, you know, Israel's asking this question, the guy says, so the light was red, right? And Israel quietly says, objection to form, and continues on, but doesn't say anything when it's being introduced at trial to impeach them. It's waived. You have to, so the objection is actually made twice. It's made at the deposition, and then it's going to be made again, if necessary, at the trial. But if you didn't make that objection initially, you're not going to be able to get it sustained then, most of the time. Some judges will, in the interest of justice, say that's not coming in. But technically, it should come in. Legally, it should probably come in. Is it something that would be appealable? Probably not. Probably not alone. You know, now that we're doing it remotely, you know, you have incidentally been getting trained for remote depositions. Because you've been focusing on, you know, although not everybody has, but when I'm speaking, and I see you speaking, you know, and your picture is there, you're paying very close attention to facial expressions. And, you know, I can tell when Stacy, you know, senses an emotion that I'm not articulating, because she has read my expression. And that is amazing. That's an amazing skill to have in this world now, with depositions, because, you know, look, of course it's easier and everybody's more comfortable having the depositions face to face, but I don't believe that anyone has any more skills than not being in person that they wouldn't have if they were on a remote deposition. You can still see their face. As a matter of fact, you're even more focused on them. You know, you could be distracted when you have all these people sitting around the table at a deposition. There's a lot going on. The court reporter has to change a tape, or, you know, all these things, you know. So you really have an opportunity to focus on if you have these magical skills. But you can, by doing this more, you do kind of pick up on how to read people's expressions a little bit better. So that's why we should do more remote things, more, keep getting used to it, because we're evolving now as litigators. And I want to be part of that evolution. I want our firm to be part of that evolution. You know, the court administration just announced that they're going to be losing $300 million in funding and stuff. So that doesn't mean our system's going to shut down. It doesn't mean cases are going to go away. I think it might mean that, you know, we're going to be in court a lot less than we think. So, you know, a lot of things are going to go to arbitration, and they've really picked up on the remote thing. So maybe this is a good thing to develop our skills. But these skills are transferable remotely, and whether they're live, it makes absolutely no difference at all. So you get assigned. You receive no training at all. You're sitting down, and the first two questions have been answered. Witness is sworn in, and you've been given the green light to go. What are you going to do now? You're going to give your instructions. Some people say that you shouldn't do that because you should just get right into it. I disagree. I use this time to get my baseline. I get this time, and I use this time to try to develop a rapport with the witness. I do not want to come off as being offensive. I do not want to come off as being aggressive. It's conversational. I want them to have a dialogue with me. This is not an interrogation. You are not in the police custody. We are just here to hear your story. That's it. That's all we want. So you start off with, my name is Joe Nohavicka. I represent the defendant in this case. And I'm going to be asking you some questions about an accident that took place in 2020. So I just have a couple of instructions that I want. You know, the first is that I just ask that you wait until I finish my question completely before you answer the question. And the reason is that the court reporter who's sitting over here is taking down everything that we say. And it's going to be put into a notebook, and it's called the transcript. And we want to have a clean record. We want the court reporter to be able to take my complete question down and have your complete answer down. So we have a solid record so that your case is clear. Can we agree on that? And they say yes. And just say, you know, sometimes, you know, when we're talking in regular conversations, we talk over each other because we anticipate what the other person's going to say. And that's normal in regular conversation, but this is very important for your case. All right, so yeah, so making it like this is their case, which it is too, and it is important, but you need a clean record. If you ever saw a transcript where people are talking over each other. It's just ridiculous. It's garbled syntax. It means nothing. It is useless. And you want this to be a tool. The next thing you say is, if I ask you a question that you don't understand, just let me know, okay? And I'll try to rephrase it. And if I can't do that, I'll even ask your attorney to give me a hand. I'll ask them myself to try to get the information that I want. I said, sometimes attorneys, they speak in legalese and they don't even make sense to themselves. And I'm going to try and not do that. But if I do, just let me know. Don't guess at what I'm asking. Is that fair? And they'll say yes. You know, so the tone that you're taking is one of not taking command, even though you are, by asking these questions, controlling the deposition. You're letting them know that their voice is going to be heard. And this is not going to be an argument. You're not being tested. You're just being asked to speak in the conversation. And I always let them know, and I know it sounds ridiculous, but I say, listen, if at any point you feel like you need a break, just let us know. Okay, for whatever reason it is, just let us know and we'll go off the record for a little bit. And finally, what I say is, if you have to speak to your attorney for any reason, just let me know and we'll provide you an opportunity to speak with them. I just ask that if I have already asked you the question, that you complete the answer and then you can speak to your attorney. Is that agreeable to you? And they say yes, and then we proceed. Those are the instructions. I say, okay, let's begin. Final thing, the exhibits, getting them into evidence, whether it's remote or not. Hopefully they'll be pre-marked if it's remote. You have the accident report, and how do you talk this document into the record? Well, what you do is you have your accident report, and everything is stopped, and you say, can we go off the record for a moment? And you ask the court reporter to please mark this. Say, Madam Court Reporter, can you please just mark this for identification as Defendant's Exhibit A? Remember, defendant's exhibits are letters, plaintiff's exhibits are numbers. So we're going to have them mark this for identification purposes only as Defendant's Exhibit A. Time out. She steps away from her court reporting machine, and she takes out a piece of tape. She writes the date on it, writes Defendant's Exhibit A, and tapes it on the paper, and hands it back to you. Hopefully, you have had proper training and you have copies for your opposing counsel. And at the same time, you hand this out. You say, sir, I'm handing you what's been marked for identification purposes only, just to assure them that this is not, it's not coming in as evidence. So it probably won't if it's an accident report. I'm handing you what's been marked for identification purposes only as Defendant's Exhibit A. Can you just take a look at that, please? And you say, okay, have you had an opportunity to review that document? And what is that document? And they tell you this is looks like an accident report. And I said, do you remember? I was just going to direct your attention down to the portion that says accident description. Do you see that section over there? And it says driver of vehicle 1 states that the light was red. Do you see that? Were you the driver, the operator of vehicle number 1 at that time? Yes, I was. That's it. The document is now part of the record as Defendant's Exhibit A. You're reading through the transcript and it makes reference to Exhibit A. You say, oh, where is that? And you pull it up from the record and there it is. And you have your Exhibit A and you say, oh yes, now I remember. That's what it is. That's how you talk a document into the record. That's how you give your instructions on your first deposition. I'm telling you, it's one of the most fun things to do once you have done your first one, when you have your first one. The best way to do it is to watch one being conducted. The second step should be to defend one, which is the easiest, and then to actually conduct one on your own, having developed your own blueprint, your own schematic as to what information, what you need, what you want, and develop your own quadrant and fill in those quadrant sectors with information that you want to get. Questions, comments?
Joe, that was awesome.
Really? Thank you.
That was really, really informative. I don't know if I'll ever do a deposition, but I took down tons of notes so that if one day I do, at least I know where to begin.
No matter what, Natalie, even if you decide not to go into litigation full force, it's always good to conduct one so that your corporate counsel, your general counsel for a company, you're better able to prep your people, your
Yeah.
managers, your whoever you're representing, the people that work with, you're better able to explain what they're going to experience because you're looking at it from another perspective. Because once you've done one, you've seen a perspective like no other, and you can't explain that until you've been through it. You understand? So it's a great experience to have under your belt, whether you're general counsel, corporate counsel, transactional counsel, trial counsel, whatever it is. And we have the opportunity for you to do it. So I strongly encourage you to do it because it's so much. And something, they're fun. I mean, they can get tough. They can get Greg's been through some tough ones, I know, but for the most part, especially when I have time to develop a strategy and I know I want to get something,
4513 that's awesome on convictions, having that in your back pocket. Because I'll typically, when they ask with convictions, and I've had it with guys who've had manslaughter convictions, I'll just say, convictions, come on, man, you're talking about crimes of fraud or deceit, felonies of fraud or deceit, and they'll agree with me and go with that, knowing 4513. Now you can get
4513 is very broad, man, and the case analysis of that statute is really, really in favor of admissibility. Unlike 603 of the Federal Rules of Evidence, which has a 10-year cutoff line, and I've even had convictions after 10 years in Fed court where we got in, and partially anyway, we weren't even allowed to talk about what it was involving. But at least we got it in. It was much older than 10 years, but in 4513, it's coming in.
Joe, what's the rule on speaking with your client during the break?
In federal court, they're very harsh, very strict about speaking with them. In state court, not so much. In any event, it is my practice, my personal practice, to inform them before the deposition that during the breaks, we're not going to be discussing testimony, just in case. And there's no reason, if there is something that they say, could you just ask about these things? I will allow them to talk to me about things like that. As long as it's something that I would be able to share with our opposing counsel without prejudicing our clients, they can talk to me about it. But I do not, I prefer to not speak. I know the questions to ask. They don't have to tell me to ask, what to ask. But the Happy Dragon client has given me a list of questions, to ask at the deposition. I was like, are you kidding? I've been doing this for about 40 or 50 years, and you're going to give me questions to ask? I mean, I looked at them anyway. During the deposition itself, if we're on a break, I want to be focusing on my notes myself. I don't want to hear their chatter. Because for the most part, they just want to, talk because they're nervous, So the answer to that, it is my preferred practice to not have any discussion about testimony.
And that applies also for defending a depo, right?
Yeah.
In furtherance of what Israel was asking, when they want to speak to you, a lot of times in my instructions to the client, I'll say, if there's a question, you don't know how to answer it, and there's something about that question that bothers me and you want to speak to me, I will tell them you have to respond, and your response is, I don't understand your question. Because if you understood the question, you wouldn't need to speak to me.
That's excellent, Greg. And I actually tell them, as I did to Angela on Happy Dragon, I told her before, so I wouldn't have to tell her during the deposition. And I did have to tell her during the deposition anyway. But I tried. I tried I tried to avoid Greg's technique, but I had to use it. It's very shady, calling your client out. And if my opposing counsel does it, it sounds like I'm being a jerk, but I put it on the record. I said, just let the record indicate that counsel was outside with this client talking with our consent for the past 20 minutes. And we're back on the record at 11:30, just in case it becomes a habit during the course of the depo. You'd be surprised. They never do it again after that.
Have you ever had a situation where somebody objects and the parties cannot agree on how to decide, and you've actually had to call the judge to decide?
Something I had earlier in my career, but I avoid it completely now. Anyway, most of the times in state court, you're not getting the judge. You're going to get the law secretary. The law secretary will decide the the propriety of the,
Oh, really?
the question. Yeah. Yeah. And these, these things are not appealable, usually. 99% of the times, their decisions during the course of a deposition are, because they're acting in the function of a referee at that point. They're not giving a formal opinion. So you'd have to make a motion to compel, and then the judge would have to rule on that motion, and then that possibly that order could be reviewed. But yeah, if you're anticipating, a really rough and abusive deposition, you have the phone number of the judge assigned. You have the chamber's number handy, and if the question's not going anywhere, so look, we'll just call the court. The other side calls the court, and it's just a tremendous waste of time.
Yeah.
It could take up to an hour just to get an answer on one question. Sometimes in the olden days, it used to require a trip to the courthouse. Like if you were in at 88-00 Sutphin Boulevard, and you had to call the judge, they would tell you to come over, and you'd have to wait around for Judge Weiss to finish his lunch or whatever. And then, he might even come out and be really angry that he got interrupted. And, that's how it was in the olden days, last year.
The court reporter would have to come with you.
The court,
Yeah.
the court reporter, it's just a mess, I just prefer if I really don't need it at that point, I just mark it for a ruling.
Handy tip for paralegals: if you're asked to do post-deposition demands, return to the back of the transcript. Right towards the end, there will be a list of all the demands that were made on the record and questions that were marked for rulings. So you can do motions and post-ABT all in basically one page. It's good to go through the transcript anyway, but check the page.
Yeah, that's because during the course, thanks, Greg. Thanks for reminding me about that. During the course of the examination, you'll be asking about certain documents that are in existence, because that's one of the purposes of the deposition as well. Not just to find out how the accident happened, but where they're keeping certain records. Do these records exist? Are there photographs, for example? So what Greg is saying, that you don't have to read through the whole transcript. Just go to the back, and it'll say items to be produced, and it'll have photographs from the day after the accident or whatever it is that you called for on page 56. So then you're going to write a letter, or you're going to draft a formal notice for discovery and inspection requesting the photographs as discussed in transcript page 50, line 14. So you're very specific about what document. And I'm going to give you one objection, and this is a good one for trial as well as for the deposition itself. And you say, what color was the light at the intersection? Well, the other guy was driving really fast, and so, I had to evade him, and because of that, I couldn't really see. That's not responsive to your question. So what you do is you say objection. Ready? This is it. Here it comes. Objection. Move to strike the portions of the answer as that are not responsive. Objection. Move to strike as not responsive. Objection. Move to strike. This is one of the most important objections that you learn, other than irrelevance or relevance or objection. Move to strike the portions of the answer that are not responsive to my question. Objection. Move to strike. That's a valid objection at trial and at the deposition, and it will be waived if you do not make it at the deposition. It will be waived if you do not make it at the trial. So this one, when we do our trial series, this is going to come up again. And I'm going to tell you this objection every single time we meet on this one. Objection, move to strike is not responsive. Because if you let that drivel go unobjected to, it's coming in at trial. Now the question is, can you make that objection if your own client is not responsive? Rhetorical question. The answer is yes. You can't at the deposition. If the opposing counsel is asking your client something that is not responsive and pretty much gives away the farm, you can object as not responsive and move to strike. Then they can't use that as a party admission for impeachment because you objected to that.
I'm just trying to think of how I would respond if an attorney objected to his own client's response. That's awesome, Joe. Thanks.
All right, guys. Thanks for your attention, and I'll see you guys at 5:30, okay?